there's two main key points that I want to make. Again, Douglas Christopher Hanson has sent in another colleague. As you know from the first one, he sent in a woman at the motion for continuance dealing with the police officers in my trial. Now this is a motion that follows up on Gale and me not seeing eye to eye. I knew for a fact that Gale Rieder was not helping me, and on record to this court, I said that to Judge Tripp. And, you know, like she said, it came a time where I was stuck. You know, imagine you hearing from a judge who spent her whole life and career seeing criminal cases. She knew I didn't have the experience to go forward with, you know, represent myself. And not only that, it wasn't enough time for me to gather everything the state had on me, which was frivolous anyway. You know, they couldn't give me information that they didn't have. And again, I tried so hard to get another appointed lawyer because Gale Rieder excluded all my information through the motion of limine, which is not on any of these court transcripts because she did it last minute. This lady is a bad attorney, and I recommend whoever have her to really look close and pay close attention at your paperwork. They talk about this long, extensive negotiating for a plea offer that I never wanted. You know, I was coerced into taking this deal because they played the mental game with me using my wife and my kids through emails. You know, this is a attorney that was supposed to be helping fight for my rights. Again, now Douglas Christopher Hanson think it's okay to jot down some more notes from one of his colleagues, so he sends a man in to step in for the next part of the motions. And why wasn't he here to cross-examine up my Dr. Harbison? I'd like to thank Andrew Harbison for coming into my life and saving me, taking me off of that metformin pill, which people don't understand. It really took a toll on me. I was taking it 4 days prior to my arrest, so it's more proof and evidence that, you know, I had this drug in me. You know, I was falsely accused of a whole lot of things, you know, and I try to show proof of it, but, you know, when there's no help, how can you show your innocence? And that's exactly what happened to me, is that I was put in a situation where the corruption was so real, nothing that I said even mattered. So here I am again pressing play on this for the world and the public to see. Now, we all understand that a random person is not going to say, I like to have a transcript of Matthew Johnson case dealing with 14C 42686, because that information ain't really important to people. But what is important is what happened underneath that information. And I've taken it upon myself to be so indigent to where I sold everything that I won from a car collision check. I sold it and I turned it into my evidence on the state. And I can tell you by facts that everything that these people are doing is wrong.
Right. It's time set for appearance. The state wishes to call the case.
Yes, Your Honor, we're here today for State versus Matthew Mayfield Johnson Jr., 14C 42686. Defendant is present out of custody with his attorney, Ms. Gale Rieder. I'm Tobias Tingley representing the state. We're here today for a motion to suppress due to some calendaring issues. The sick attorney, so you're in day 3 of a trial, Your Honor. We're, sounds like, unable to hear the full hearing today. We will be hearing from a defense witness, a doctor in the case, and then setting over the remainder of testimony for 6:30. That's June 30th at 2:30, or excuse me, 2 p.m. Your Honor.
All right, thank you. Mr. Johnson?
Yes, ma'am.
Go ahead and stand up. Good morning.
Good morning.
So, Mr. Johnson, unfortunately, judges' cases sometimes have a life of their own. I thought this case that I'm trying now would be done yesterday, early afternoon. Yeah, that didn't happen. And so I've got a jury coming in at 10 o'clock. And so really we can't do the motions, okay? And I apologize for that.
Okay.
Okay. There is a doctor coming, however, from far away. And I told Ms. Rieder that I'd go ahead and listen to the doctor because we don't want to inconvenience him more than we need to. But the other issue we need to take up is it seems like at first you were not happy with Ms. Rieder's representation, and then you were kind of okay with it.
I'm never okay with it at all.
And so here's the question. In a request for new counsel, I need to put you under oath, and you need to explain to me why, in detail, you don't want her to represent you.
Absolutely.
So if you raise your right hand, other right hand, there you go.
Sorry.
Under penalty of perjury, do you swear or affirm the information you're about to give in this court and cause shall be the truth?
Yes, no.
All right, go ahead and have a seat. Now, by my record, you've had a number of attorneys appointed by the court.
Yes.
Do you remember how many?
I have 4 of them and 2 substitutes.
Okay. You've had 4 attorneys and 2 substitutions by the court.
Yes, no.
What about the other 2?
I know. The first man, he was the arraignment, and Carrie Weiler mentioned that it was her practice, their practice, to have him step in. So I didn't count him as a public defender. But the remaining on the 27th of May, which was set for a preliminary hearing that I never got because Carrie Weiler and District Attorney Douglas Hanson never showed to it, and I have a judge on audio transcript actually setting that court date, and they missed it, and she sent in, Carrie Weiler sent in Michael Lee Griffith in her replace. She replaced him and didn't show up, even though she knew she was my attorney at the time, and that I had a preliminary hearing set, and I was wondering why I was stripped from that when a judge, Senate said, preliminary hearing set for May 27th and an indictment if one should be issued. And the conflict of interest with the public defenders started to occur is because I never waived my preliminary hearing rights away. And I found out through my audios that Carrie and Douglas Hanson had waived my preliminary hearings away through email, off court record, something I never knew about because I never talked to Carrie Weiler ever in my life.
But you were subsequently indicted.
Yes.
Okay. And you had the public defender at that point.
I didn't get an indictment until October.
Okay. So once you got the indictment, who was your lawyer then?
Jessica Kempfe.
Okay, Ms. Kempfe. And did there come a time when you became did not like Ms. Kempfe's representation?
To be completely honest with you, Your Honor, I only met her one time, and I had emailed her expressing why my preliminary hearing was stripped from me, why nobody came. So she actually investigated it, and she said Carrie Weiler wrote in her notes that she made a visit to me, and then I went as far as to go down to the Marion County Court annex, and I asked to get a printout of her visitation log, and come to find out she never made any professional visits to me. And what happened was she did make a visit June 1st, which was after it was, I can remember very vacantly that it was like real late. I was laying in the bed in my cell, and they opened it up and said I had an attorney visit, and it was finally Carrie Weiler, who I never even met, but previously she already had waived away all my rights. So
did you ask that she be that someone else be substituted in as a lawyer?
Actually, she wrote, because I had wrote a complaint on her misconduct to the state bar, and we were going through this for about half of a year, 6 months, and she wrote in her report that she wasn't able to, or she quit the job as public defender. She took up a job down in Benton County for assistant district attorney, and then that's when Jessica Kemphy replaced her.
Okay, but Ms. Kemphy is the one that you filed a bar complaint against?
No, I found the complaint against Carrie A. Whiteland, Your Honor.
Okay. All right, so then Ms. Kemphy filed a motion to withdraw because there was a conflict between you and her.
Right.
Okay. And so then what happens? I appointed Mr. David Coons.
Yes.
Okay. And then Mr. Coons was your lawyer, court appointed, and you then asked, after you had Mr. Coons, you asked for a different lawyer.
See, that's where they're confusing you at, Your Honor. I never ever asked for a public defender. I stressed the issue of why didn't the district attorney take this evidence that he supposedly had to a preliminary hearing and actually get an indictment, you know, and that's been my argument up until this day, because it's my constitutional right to a fast and speedy trial.
Can we move past the preliminary hearing?
Yes.
Okay. So, you had Mr. Coons.
Yes.
And he filed an affidavit that said the attorney-client relationship has deteriorated to an unaccepted level, and that he was also ethically required to withdraw, just like Ms. Kemphy. So, do you feel like that was accurate, that you guys really didn't get along?
I talked to him twice in actual meetings. Most of it came through mental, and that was through emails. I've created several different folders and keeping up with these people. And
can we just ask you this? Did you want Mr. Coons to stay as your lawyer?
he was actually a good attorney. What I found out is that his disciplinary action through the state bar, because I was a little bit worried about him, and they want me to explain to them what happened May 16th, but they never let me explain it, or they never ever let me.
So you turned Mr. Coons into the bar?
No, I didn't turn him into the bar.
You said something about they wanted you to explain about May 16th. We're talking about Mr. Coons.
Yes,
Who wanted you to explain?
Mr. Coon wanted me to explain to him why I went to the bar on my concerns about him, because I had done some investigation on him, and I told him...
So
you went to the bar to talk about Mr. Coons?
Yes.
Okay.
Yes, ma'am.
Okay. So then I appointed Ms. Rierder to represent you.
Yes.
Okay. And what are your concerns about Ms. Rierder's representation up here?
From when Mr. Coon withdrew off my case and passed it off to Ms. Rierder, I don't know what transpired between them two, but she instantly had this attitude towards me, which made me feel like she wasn't there to listen to me. I try to exercise my right as far as bringing some type of support with me, because I've been through so many different attorneys, and I was having trust issues. So I was like, I talked to my doctor, and he advised me to bring along somebody that could help me, because of my stress and my anxiety problems and stuff is real bad. So I took my support with me, and she immediately kicked them out. Like, She kicked them out, didn't let me explain nothing. She kept on saying how much of a concrete case this was, and never once have I been able to introduce any of my evidence that I got from Kerry Weiland. In the first discovery that I got was some audio CDs which proven that I gave officers only to search my vehicle, and I was trying to show her the proof so I could build a stronger and better defense. But I don't have no say. I only talk to her through emails, and this is what I do every day, is try to read and understand her, because there's I can't meet her. She canceled my visits at the state bar, claiming that she needed more time to file motions that Kuhn filed for me in February 5th.
Sir, who are you? Sir, who are you?
Just a friend of Matthew's. I just literally did some of these. I've been helping him out through this. I can leave if you like. But listen to it. My name's John. Graham John.
Have you written emails to Ms. Rieder?
That's not.
Okay, all right. You can remain.
This is John.
All right. So, you write back and forth in emails, is that correct?
Yes, ma'am.
How many emails have you written back and forth?
This whole binder right here, I would say over about 100 emails.
Between you and Ms. Rieder?
Yes. And not only that, Your Honor, the day that the district attorney read off that plea, I was kind of confused because they had sent me a different plea offer. That wasn't even a plea bargain that was explained to me properly, because for a long time I was given a different plea offer, and not only that, the district attorney sent her the same exact plea, but when she came in here, she explained another plea offer to you. And moments after that, after court that day, she then wrote me an email explaining to me how she can get certain charges to go away and stuff like that. And it's like, she know that I don't want to take a plea offer, so why?
All right. So let me tell you where we are right now. This is the lawyer you will have, or you can represent yourself. Those are your two options. You have a right to a court-appointed lawyer, but you don't have the right to any court-appointed lawyer. You have the right to a court-appointed lawyer. And in this circumstance, we've provided a number of opportunities for you to have a court-appointed lawyer. It is not unusual for a lawyer and their client to see things differently. That's not unusual. It's not uncommon. It's also not unusual or uncommon that a lawyer will say, this is a good argument, this is a bad argument. You can make progress with arguing this. You are never going to make progress on arguing this. Or you don't have a very strong case, which is potentially not in your best interest to take it to trial, or you have a good case. And I know it's an imposition to go to trial, but you should. I don't know what has been said. Here's the circumstance. If you wish to represent yourself, that is a serious decision. I had you think about that the last time I talked to you, and ask that you think hard about that decision. You're not legally trained. If you try and represent yourself, people who do that tend to make mistakes, which are not in their best interest. An attorney has experience and knows the law and knows how to proceed in a trial. You can make trial strategies like I talked about. This is a good argument, this is a bad argument. But sometimes those trial strategies, again, could be a mistake. So the question is, you have your right to remain silent. If you choose to testify at trial, you're giving up that right to remain silent. You do not have to testify at trial. The jury cannot use that against you. You've been told what the possible consequences are if you were convicted. Those are big consequences. There will be issues like these motions or other issues at trial that you are not schooled to understand and argue on your own. Ms. Rieder has told me, and I believe that should be a representation of an officer of the court, she is ready to go to trial on the date that I set. She is ready for motions on the date I set. It is your decision whether or not you want to have Ms. Rieder dismissed as your lawyer. That said, you're not going to have a new court-appointed attorney. So you're choosing between representing yourself and being represented by Ms. Rieder, because it's really clear from the cases of the Supreme Court, Court of Appeals, you have a right to a lawyer, you have a right to a court-appointed lawyer, but once you gin through a number of lawyers, they say, we've met our burden to provide you a court-appointed lawyer. And that's where we are. I need a decision. Do you want to work with Ms. Rieder, even though at times you may not agree? Even though at times you may not agree on a decision for you to take the stand, a decision to put on evidence. She may tell you it's a bad idea. You may not agree. I can't promise you you're going to agree. But acting in your best interest is her job. Whether you like it or not, she will never refuse to put on evidence that you insist that you wish to put on. Unless the person's lying, and then we get into other issues. Because she can't knowingly put a person on the stand who's going to lie. But other than that, so, I understand your position. However, it is a really, really, really bad decision to give up the services of a good lawyer to represent yourself, even if you don't see eye to eye. So, there we are. Mr. Johnson, what do you want to do?
I'll keep her and work with her.
Thank you.
You're right. I can't get up and represent myself in front of. I just don't have the experience, like you said, flat out.
All right, Ms. Rieder, you are on the case for the remainder of the case, whatever the remainder of the case shall be. I assume that you will continue to give your advice which he may or may not like. And he may follow it or not. And I assume that other than putting on a witness to lie, you will listen to your client's instructions, whether they're in his best interest or not. Ms. Rieder.
And thank you, Your Honor. And based on Mr. Johnson's statements under oath to the court today, I assume that he now intends to respond to my emails and will provide me with information about the witnesses or evidence that he has so that I can prepare his defense.
Okay, those are reasonable requests.
Yes, it is.
Okay, and if you don't give her what she needs to know, she can't represent you well. Okay? Now, it may be that you have some internal reason that you don't want to give that up. Just understand that ties her hands as to representing you well. If you were someplace for some, let's take a hypothetical. You were someplace for some bad reason, okay? Whatever the bad reason may be, committing a theft. But somebody tells a police officer and you get charged with committing an assault on the other side of town. Would be in your best interest to tell her you committed the theft. And that's where I was at the time. I wasn't committing this over here. Now, she doesn't have to tell anybody you were committing the theft, or she may. Do you understand that?
Yes, ma'am.
Okay. You have to be absolutely honest and straightforward with her so she can represent you. She's not going to tell anybody what you tell her unless it's in your best interest or it helps your case. That's her job. Your job is to trust her because that's her job to help you. Okay, Mr. Tingleaf, we're going to listen to this doctor when the doctor comes, correct?
He's here.
Oh, perfect.
He's in the hall.
All right, let's do that.
Dr. Harbison.
All right, thank you. Mr. Johnson, if you'd stand back up. I'm sorry I have to ask this, okay? And I apologize for the fact that I have to ask this. Have you had any drugs or alcohol today?
Not me, no.
Okay, not you. Are you sure of that?
Yes, ma'am.
And under penalty of perjury, do you tell me that you have not consumed drugs or alcohol today?
Yes, ma'am.
All right. And do you fully understand what has happened today?
As far as what?
As far as you deciding you're going to go ahead and proceed with Ms. Rieder?
Oh, yes, ma'am.
Okay. Anyone made threats or promises?
No.
All right. Thank you. Go ahead and have a seat. The question became who of a couple of people had engaged in inappropriate behavior before coming to court. I wanted to make sure that Mr. Johnson was not that person.
Straight and narrow.
Okay. And so we've accomplished that. I think that's consistent with what the officers have told me, that of a couple of people, it was not Mr. Johnson that was the problem. Was not the person who had engaged in behavior that they shouldn't have engaged in before they came to court. So it's consistent with what the deputy impressions were. I believe Mr. Johnson for the record, and I believe that it's knowingly and voluntarily that he remained with counsel. Now, doctor, if you come forward. Raise your right hand. Under penalty of perjury, do you swear or affirm the information you're about to give in this court and cause shall be the truth?
I do.
Have a seat, please. Ms. Biggs, can you go tell my jury that we are, again, running behind, and I will get to them as soon as I can. But they could probably go on break for 45 minutes.
Yeah, I'll check them in.
Okay.
I just need a name for the witness.
What's your full name? Spell your last name.
Andrew Ross Harbison, H-A-R-B as in boy, I-S-O-N.
Ms. Rieder.
Thank you, Your Honor. It's Dr. Harbison, isn't it?
Yes, it is.
Okay. What's your training, Dr. Harbison?
I'm a board-certified internist, internal medicine.
Right. And what does that mean that you've had in the way of training?
What that means is I've had 1 year of what's called internship, which is pre-training prior to residency, and then 2 years of training in internal medicine solely. And then the board certification implies that I've passed a test and met the requirements of the certifying body.
And how long have you worked as an internist?
So I've worked as an internist since, off and on, since 1997.
In lay terms, what does that mean that you do?
What that means is that I practice what's called general internal medicine, which is basically adult medicine. So it's all aspects of medicine pertaining to adults.
Where are you employed?
I'm presently employed with the Rose City Urgent Care and Family Practice Clinics in Portland, Oregon, or in the greater Portland area.
And are you familiar with the medical history of Matthew Mayfield Johnson, Jr.?
Yes, I am familiar, as available on the records in that facility.
And did you have a chance to look at those records in the fall of last year regarding some diagnoses that were made?
Yes, I did.
And what did you see in those records?
What I saw in those records was that a diagnosis was made of diabetes mellitus type 2 sometime in the spring, particularly sometime in early May or late April of 2014.
And as a result of that diagnosis, was any particular course of treatment prescribed to Mr. Johnson?
Yes, a medication was prescribed, specifically a medication called metformin.
Say it again.
Metformin, M-E-T-F-O-R-M-I-N.
Thank you.
And during May of last year, was Mr. Johnson taking metformin?
Yes, to the best of my knowledge, he was.
Just to clarify, were you the prescribing physician?
No, I was not. This was prior to my employment with the facility. His provider at that time, his primary provider at that time, had prescribed the medication.
Specifically on May 16th, 2014, was Mr. Johnson taking metformin? To the best of your, he was under prescription.
By the review of the records, yes, he was.
All right.
It was under prescription, but you don't know specifically if he was taking it or not?
I can't say specifically that he was taking it, but he certainly was prescribed the medication, and I can confirm that the medication was obtained.
Okay. Thank you.
Thank you. Are there, have you had a chance to review medical records from Salem Hospital regarding his treatment just after his arrest on May 16th, 2014?
Yes, I did.
And what were the symptoms that led him to be taken to Salem Hospital?
Nausea and vomiting.
Was the diagnosis of diabetes by another physician accurate?
At the time of his emergency department evaluation, the diabetes diagnosis stood. The reason for that is the emergency department's physician's ability to diagnose type 2 diabetes mellitus under the circumstances when he saw Mr. Johnson was not possible.
And I'm sorry, I want to make sure we understand your answer. Are you talking about the emergency room at Salem Hospital, or are you talking about the urgent care clinic in Portland?
So, as I understand the question, you want to know whether or not the emergency department physician at Salem Hospital was able to diagnose type 2 diabetes mellitus on May 16, 2014. Is that correct?
No, I'm sorry, and it's probably my inartful question. Is it your belief that the original diagnosis of diabetes and the decision to prescribe metformin was an accurate diagnosis?
No, I do not believe it was an accurate diagnosis nor an appropriate action.
And if one is prescribed metformin when one does not have diabetes, what is the body reaction?
So the body reaction to someone, whether they have diabetes or not, is not substantial. In other words, the effects of metformin on somebody who does not have diabetes is, for the most part, no different than somebody who has diabetes. However, the adverse effects that are related to metformin can be seen in both people who have diabetes or do not have diabetes if they're taking the medication. Does that answer your question?
And what would those adverse effects be?
At least a third of people who take metformin have gastrointestinal adverse effects. And of those, although there aren't percentages, nausea and vomiting can be substantial.
And that sort of nausea and vomiting might interfere with their ability to understand what's going on at any given moment?
I would say that to the extent that they're being ill, and the experience of being ill would potentially impair somebody's ability to act, shall I say, clearly.
Right, thank you. Nothing further.
Thank you. Have you ever actually met with the defendant, Mr. Johnson?
In meeting in what type of circumstances?
In medical setting?
Yes, I've met with Mr. Johnson frequently since the summer of 2014.
And how did so since summer of 2014, that's when you realized it wasn't diabetes?
Yes, I took over Mr. Johnson's care in summer of 2014 when I began working for the facility that I described earlier.
Okay, what's he prescribed now, and what is the diagnosis?
Yeah, there is no diagnosis now. In retrospect, if I'll go into detail if necessary, but I believe that the diagnosis of type 2 diabetes mellitus was actually incorrect.
Did he have any health problem?
No, as far as type 2 diabetes mellitus, no, he does not have a health problem in that regard.
Okay. Yeah, you weren't at the hotel on May 16, 2014?
No, I was not.
All right. Would this nausea cause people to engage in sexual behavior?
No. Yeah, this is primarily an isolated impact on the body's perception of gastrointestinal distress.
What about to send text messages, that sort of thing?
I would say that actions can still, in other words, a person's ability to act are not necessarily impaired. But as I said earlier, whether those actions can be claimed to be of clear mental faculty, I would argue that's possible that they were not being done under clear mental faculty. As I said, based upon what I would consider a common sense experience of people, for most people who have experienced the nausea and vomiting and what that sensation is like and how that might impact the ability to think clearly or act clearly.
All right. Would marijuana benefit, or I guess help, that nausea and vomiting condition?
Yeah, marijuana has been shown to actually improve nausea. It can improve nausea. The mechanisms by which are pointless to go into, but yes, it could.
And so, someone taking it wouldn't, because it's caused by the medicine, there wouldn't be an adverse effect with those two. I know sometimes
would they interact?
Medicine.
No, to the best of my knowledge, no, they wouldn't. Some of the evidence I've reviewed suggests actually that the use of marijuana for symptoms of metformin, nausea, and vomiting is not effective.
Is not effective?
Yes, but that's, of course, under clinical circumstances.
Okay. And have you had people in your office who are experiencing the nausea and vomiting?
I have had people in the past, not present, but yes.
Okay. And were you able to have communications with them?
I was able to communicate with them. The circumstances under which I saw them, they may not have been acutely nauseating, having acute nausea or vomiting, but certainly they were able to speak with me. I've had people who have had nausea and vomiting, however, not necessarily related to metformin, who have had difficulty expressing their thoughts clearly, mainly because they felt ill. But with time, I would say that depending on the circumstances, I would say it would depend on whether somebody could speak with me clearly about a subject or not under the circumstances of those symptoms.
You weren't at Salem Hospital immediately after this?
No, I was not.
All right. You weren't there the day that the police interviewed the defendant?
No, I was not.
All right. So you don't know how he acted that day?
No, I do not know the specifics of how he acted, yes.
Has anyone ever been untruthful with you in order to seek drugs?
I cannot verify that. I suspect it, but I cannot verify that.
Okay. I have nothing further.
Ms. Ryder?
No redirect.
All right. Thank you, Doctor. I appreciate your coming. You're free to go.
Certainly.
All right. Just for the record, I want to say that basically this is the beginning of the motions hearing, and so this testimony is part of the motions hearing. So we've begun the motions hearing, but the rest of the motions hearing, because I had a trial that went over through hopefully very little fault of the court, we have to continue on a different day.
And Your Honor, I'm asking the court for just leeway for a moment for me to put on the record that 3 motions have been filed, just so that we clear the record.
Okay.
3 motions have been filed. One of the motions is a motion to dismiss for lack of proper venue. A second motion is a motion to suppress regarding a search. And a third motion is a motion to suppress defendant's statements. This testimony is applicable to the third motion. I believe it has no applicability to the first 2 motions. I just wanted to put that on the record so that we're clear, since we have 3 motions.
Okay, perfect. All right, that is what we're going to do today. Mr. Johnson, continue to comply with your release agreement and try to get Ms. Rieder the information she believes she needs to represent you well. Okay. This case is going to go to trial. We all know that. This case is going to go to motions. We all know that. So let's all share information so that all the information gets on the record if that's appropriate. Okay? We're in recess.
Thank you.
Again, Gale Rieder chose to help the district attorney. I don't have to tell people much about that because she tells on herself. Like, all the motions that David Brian Kuhn put in were true motions, and I like to apologize to Mr. Coons for not being able to stay firmly on my case due to his write-up and his disciplinary that he had through the Oregon State Bar. That is the reason why he withdrawed off my case, and I have proof of that. But to keep you guys noted that this lady, Gale Rieder, absolutely hated me. There were times that when we were in court where she said I was stupid, uneducated. My sister had more sense than me. My friends have more sense than me. And this is a lady that was supposed to be there to help me. As you can hear in this video, that the judge stuck me with her for the remaining of my sentence or fight to these people. But at the same time, it's like, dang, what would you do? Take the state offer or let her, this Gale Rieder chick, lead you into being hung for 160 months? It was so much weighing on my mind, and they knew mentally how to control me because of, again, Gale Rieder had made me take a psych eval, which I passed, and I proved that I could assist in aid in my own defense, and she put that on the last minute motion to eliminate because my information was stronger than the district's attorneys, and they knew that. So again, follow me as I keep uncovering the truth on how I was wrongfully convicted of charges that I didn't do. I got a felony charge for a crime I never committed. I got a promoting charge for a crime I never committed. That's why I'm allowed to be at home with my wife and my kids, because they knew beyond reasonable doubt that the information that they had and was trying to prosecute me with had been already charged to my wife prostitution citation. So I'm asking for the public help. And again, follow me as I uncover this corruption.